I published a video there the other day on Facebook to do with the Sunday working entitlement to a Sunday premium if you work on Sunday. And somebody posted or commented that wasn't that old law. Yes, it is old law. It's pursuant to the Organisation of Working Time Act 1997. But nevertheless, it's still a law and it's still very relevant. And the next day after that comment on the Facebook video, I see a report in the Irish Times there about a leading Irish retailer who have a blanket practice of denying premium Sunday pay. The chain in question is Jack and Jones retail shops, and a former employee, brought a claim against the company in relation to their failure to pay a Sunday premium, and the employee was awarded over €10,000. But the interesting thing about it was that the representative for Jack and Jones accepted that they didn't pay, as a matter of course, a Sunday premium, and that the contract was silent on the issue. They're a menswear shop, apparently, Jack and Jones. They've been ordered by the WRC to take steps to ensure all of its staff are paid extra for Sunday work. The clothing retailer admitted it did not pay a premium to the workers. They have about 40 full-time equivalent staff in Ireland, and in this particular case, there was a gentleman let go, as it were, 5 weeks after making a working hours claim. He was awarded €10,725. The WRC was ruling on the complaints by a chap called Jake Quinn under the Organisation of Working Time Act 1997. He alleged that he got no premium pay for 14 Sundays between April and July 2022. He earned €11 per hour for a 37.5-hour week, and he alleged he did not receive bank holiday entitlements for 4 dates in March, April and May of that year as well. Mr. Quinn, who made the complaint, said he was let go in July 2022, only 4.5 months after he was hired. So this chap hadn't got the protection of the Unfair Dismissals Act because he didn't have 12 months service. Nevertheless, there's nothing to stop him from bringing a claim under the Organisation of Working Time Act, which is precisely what he did. He submitted that the working hours complaints to the Workplace Relations Commission, he submitted the claims on June 19th, 2022, and this was about 5.5 weeks before his employment ended. His evidence was not contested by the retailer. The retailer's representative, William O'Reilly, said, quote, "The company does not pay Sunday premia." The complainant was paid a standard rate of payment, and under his contract he was required to be flexible in his hours of attendance, Mr. O'Reilly said. So he was the representative for Jack and Jones. Mr. O'Reilly added that the complainant was paid 33.78 hours in holiday entitlements, which Mr. Quinn agreed at the hearing had included a portion for holiday pay. The Workplace Relations Commission adjudication officer noted in his decision that the company's representative accepted that Mr. Quinn worked Sunday hours and that it does not pay any form of Sunday premium. He also said that it's also accepted that the contract is silent on this issue. Therefore, the complaint by the employee in question was well founded. The adjudicator as well noted that the working time legislation gave him jurisdiction to award up to 2 years' pay in the case of a breach of the Act. He ordered the Jack and Jones to pay Mr. Quinn €10,725. He said the sum was equivalent to 6 months' wages for Mr. Quinn and was just and equitable, having regard to all the circumstances. He also ordered Jack and Jones, the retailer, to comply with the payment of Sunday premia for all its employees. It's interesting to note that this employee was only there a relatively short period of time, less than 6 months, I think, and nevertheless he was awarded 6 months' wages for the breach of the Sunday premia entitlement and the breach by the employer. The other important thing to consider is if you're an employer, then if you don't pay Sunday premium, for working Sunday, for Sunday working time, well then you're going to be in significant difficulty. In other words, the case will go against you. And do bear in mind, one of the most important things that the adjudicator has said here is to draw attention to the fact that the adjudicator could award up to 2 years' wages for the breach. So strictly speaking, the breach might only go on for a month or two, but nevertheless the adjudicator does have discretion to award up to 2 years' salary for breaches of the Organisation of Working Time Act 1997. And that is the particular act that deals with the entitlement for Sunday premium pay. So I may have published a video, as I say, last week on Facebook about the entitlement to Sunday premium. Somebody may well correctly have pointed out that this is old law. Yes, it's from 1997, but nevertheless, employers, unfortunately, some employers are still in breach of it and don't pay. And if they do adopt that position, well, then they're leaving themselves open to claims. And in this particular case, I note that there's 40 employees, so I don't know what the employer is going to do in respect of the other 40 employees. I don't know what the other 40 employees are going to do in respect of bringing claims against the employer. That's entirely a matter for themselves. But clearly, if one employee has been awarded €10,750, then perhaps others might be encouraged to bring a similar claim. That's assuming that the employer doesn't somehow head them off at the pass, as it were. As I say, I have no knowledge of what's going on. I have no knowledge of what employees might do or employers might do. I'm simply speculating that if there's 40 employees and if one of them has won €10,750 and if the employer has given evidence and his representative has said we don't pay Sunday premium, well then, just as surely as day follows night, then it's possible that other claims might follow. Hope you find this video useful. I would appreciate if you gave it the thumbs up down below. Thanks a lot.